Today we will discuss or we will start discussion on the criminal liability. See, this new chapter is very lengthy because it would cover many offenses under the Information Technology Act 2000, and there are some offenses under the Indian Penal Code also, because the cybercrime means any act or any offense either committed through the computer or against the computer. So it's not that exclusively IT Act only cover the cybercrime. Sometimes even the Indian Penal Code also use. And this misconception or the confusion that only offenses categorized under the IT Act are the cybercrime is not true. The recently two very famous apps, this Sully Deals and Bully that even was on the everyday newspaper, and many people ask that how, because in that case only the Indian Penal Code, under Indian Penal Code FIR was registered. So here also in our syllabus you will find that the cyber stalking, there only section 354D and 509 IPC is mentioned. And someone may ask that, sir, then IT Act is not there, so why we are discussing? So see, the cyber crime word has not been defined anywhere here in the IT Act or somewhere else, and so we have to see only the understanding, or you can say the present legal regime, that any crime committed through computer, whether that is covered under the IT or may not, but that would be considered as the cyber crime, either through the committed through the computer against any property, person, state, or against the computer means the computer resource, computer data, etc. So with this note, see what actually we are going to discuss. Here the major portion is the Information Technology Act chapter 10, and in the chapter 10 if you see that from the section 65, the chapter 11, offenses from the section 65 to the section 78. But in this chapter some provisions you will find that are procedural means whether the offenses are compounding or not, whether who will do the investigation, etc. And if you have some idea of the criminal procedure, because sometimes student ask that, sir, for the civil wrongs you have discussed the procedural portion, that no need to go to the court, file the complaint before the adjudicating officer. So in case of the cyber crime, are there different or the separate court? No. See, CRPC will be applicable, because for the civil matters the tribunal and the different forum is possible, but for criminal matter it would not be possible. You have read in the constitutional law classes that in Kathi Kalu Ogad case, Article 14 was argued that the Article 14 of the Constitution not only talk about equality before law, but also talk about equal protection. So the separate court or the tribunal are not possible under the the criminal law. Yes, for some cases like the NDPS, POCSO, some special judges are appointed, but then also the Article 14 has to be taken into the consideration. A separate procedure would not be provided, so that would be adversarial or prejudicial to the accused. So here the some sections you will find there. Along with that, the CRPC will come into the picture. If you read section 2N of the Criminal Procedure Code 1973, that offense means any act punishable under any law, and the complaint made under the Cattle Trespass Act. So Criminal Procedure Code would be applicable, and the express provision here in the IT Act that would apply having the overriding effect on that. So suppose the offenses are made here compoundable, maybe under the CRPC that would not be compoundable, but because here they are specifically held to be compoundable, so that would be compoundable. To which court they will be tribal? For that we have to see, for every offense we have to see CRPC में जो हमारा शेड्यूल है, फर्स्ट शेड्यूल जो CRPC में अटैच है, and in that schedule there is a list, serial number, offense, then tribability, cognizable and compoundable, वो जो पूरा list है. So that list you have to see. That list in the schedule 1 is divided in two portions. The first part is for the offenses under the IPC, and the second portion is offenses under any other law. So there then you see this CRPC, you will find that if the offense is such having the punishment up to 3 years, so the any magistrate, if the punishment is 3 through 7 years, so the first class magistrate, and if 7 to above, then the district judge, okay, session judge, sorry, not district judge, session judge is the word used for the criminal cases. So these things we will discuss. Now here the different offenses we have categorized. You will not find this categorization under the IT chapter 11. Like in the IPC, the offenses has been categorized according to their nature. If the offenses are against the human body, so you will find those under the offenses against the human body. So from section 299 to 377. Then you will find the chapter offenses against the property. You will find the chapter offenses against the public servant, offenses against the marriage, offenses against the property, offenses against the weight and measurement. So similarly here, for the sake of simplicity, we have categorized these things, these offenses that we are going to discuss here under the 6 category, and that accordingly we will discuss. The first here we will discuss is the tempering of source code. Tempering of the source code, and here we will discuss section 65 of the IT Act. On that point we will discuss two cases, one by the Honorable High Court of the Andhra Pradesh, and on the definition of the computer also we just have discussed some portion of this case. The name of this case is Sayyid Asfuddin versus State of Andhra Pradesh 2006. This Andhra Pradesh High Court judgment. Then the second case on this point we will discuss will Sanjay Kumar versus State of Haryana. Then the second category of the offenses we will discuss is the hacking, the different activities that were made as the cyber wrong under section 43. If those activities are done dishonestly or fraudulently, either dishonestly or fraudulently. What is dishonestly? As defined under section 24 of the IPC, that means dishonestly means to cause wrongful loss or wrongful gain to any other person. And then what is wrongful gain and wrongful loss? We again have to see section 23 of the Indian Penal Code. Fraudulently means anything that is done to defraud the other. So with that mental intention, because in the criminal law it is always this legal maxim that actus non facit nisi vincit rea, an act is not crime unless and until it is coupled with the mental or with guilty mind. So mens rea is essential, and I think this thing you have read in your criminal law classes. But the mens why it is important and why this discussion we are doing? Because the burden of proof is on the person who go to the court. It's either it is a civil case or the criminal case. If you see Indian Evidence Act 1872, there is the section 100, and section 100 talk about that burden of proof is always on the person who goes to the court and want relief in his favor. So this burden never shift. But burden of proof is always on the person. This onus of proof under section 103 of the Indian Evidence Act goes on changing from one party to another. So there is difference between burden of proof and the onus of proof. Here, if any question you have, I will take those question also at the end of the class. You just keep writing. Then the next thing is that the mens rea as specially has to be mentioned, and how you will determine, how you will find out, because for as a criminal law student or as a law student, you have to see that whatever the requirement of the section we have to comply with. See, in every criminal section we will find certain words that shows the mens rea, that shows the guilty mind, and that specifically has to be proved. You will find the words like with intention to cause, you will find the word with the knowledge of doing, you will find the word reason to believe. So these are the three classes, or you can say three stages of the mens rea. The first one is the intention, that is maximum, then the knowledge, and then the reason to believe, as it is defined under 26, what is reason to believe. And then you will find the words like dishonestly, you will find the words like fraudulently. So these words showing the mental intention or the mens rea, and these things has to be specifically proved. Now the next the second group, we are saying that the all those activity under section 43, if doing with the dishonestly or the fraudulently, will be punishable under section 66. So section 66 we will discuss, and on the section 66 we will discuss the case state of Andhra Pradesh through Inspector of Police Cyber Crime versus Prabhakar Sampath. Then the next group of the offenses we will discuss. See, we all have faced this problem that someone called to you or to any known to your person that, sir, I am speaking to this particular bank, and your credit card is going to expire, or debit card is going to expire, or KYC is required. By any misstatement, or with that intention, he wanted to get your credential, and after getting that credential, using that credential and do the transaction. So here the two acts are there. One is when the person dishonestly getting your credential by showing some other person, and in second thing, then that person uses your credential, uses the credential of other persons. That means that is impersonation. Suppose a person, suppose you have a bank account, or that have this particular password and the pin word, and you are putting it. So okay, suppose same thing electronically, same thing you are doing offline. So suppose some person other than you go to the bank, and then he withdraw the, for withdrawing the money, fill the this that receipt and put the signature, so that would be impersonation, section 419 of the IPC. So similarly here also, any person other than you, if use your credential, that means he is also impersonating, showing that he is you but he was not you. So here the two new sections has been inserted in 2009, section 66C and section 66D. And many times, or I think because I have experience in my family, you have also have experience that this type of the transaction happen. So section 66 and section 66 section 66D we will discuss, and these things will be very helpful for your practical purposes also, and in the as an advocacy also you will get many cases. So identity theft and cheating by personation, in the technical language it say that phishing, spoofing, password theft, etc. So here this thing we will discuss. This is the third head, and one case we will discuss here, NASCOM versus Ajay Sud. Then the fourth group we will discuss is about the obscenity and the pornography, because the information technology make it so very easy to send the bulk of the information in any form from one person to another person, and so at the same time sometime it also used to publish or disperse the or disseminate the obscene and the pornographic material. So section 292 of the IPC make it punishable for publication and selling the obscene material. So similarly here also under the IT Act there is the prohibition, and it is punishable. So uh, you know how to determine that whether a particular material is obscene or not, that is very difficult. And here different test has been laid down. So these tests started from Regina versus Hicklin, known as the Hicklin test, because obscenity is not a constant concept. It changes with the society. Maybe a particular thing is obscene in Iran or Iraq may not be obscene in India, or what is obscene in India may not be obscene in the Canada. So it's very difficult, and the main emphasis of our discussion or focus will be to discuss many different cases, from the Ranjit Udesi case to the latest Avik Sarkar versus State of West Bengal, the latest Supreme Court 2014 case, to find out that how to determine a particular material is obscene. Obscenity is different from abusive language, filthy language, or the other thing. Obscenity means that material that you have targeted to the lascivious interest. Okay. And this question was arose when this Bandit Queen movie was there, and this woman was shown as the in the naked, or many other in the movies or the picture we will say that there are naked scene or some other scenes. So that we will the discuss. And this is very important person every time one question is asked on the obscenity portion. Here 2-3 cases we will discuss. The one case definitely I have said that Avik Sarkar versus this state of West Bengal, then state of Tamil Nadu versus Suhas Kutti, then Makdul Fida Hussain versus Rajkumar Pandey, Vaibhav Jain Vice Chancellor Devi Ahilya Vishwavidyalaya, and state cyber complaint versus Yogisa. So these two cases, state of Tamil Nadu versus Suhas Katti and state cyber cell versus Yogisa. These are the cases because now people put or made the account of any girl, and then in consequent phone number or some address is put on that particular website, and then women get the the obscene calls, etc. So in that case, how that has to be dealt with, how had to be checked with. Yes, still we don't have the robust system in that, but the police uses police registered the cases, and then with the help of the IPC or the investigation, because we have the dedicated cyber police station or the cyber cell, through that the investigation is made. Then the pornography here, because I said that this fourth one is obscenity and pornography. The pornographic material is the sexually explicit material where the sexual activity is explicitly clearly shown. And here uh, along with this pornographic material, there is one another sections that is bodily privacy. If some person capture the image where a person is naked or in such a position that violate its privacy, so in that case it is also the punishable the offense. So bodily privacy under section 66E is punishable, and section 67A is making sexually explicit material or pornographic material punishable, and section 67B making the child pornographic material. So here we will discuss the POCSO Act there, because there in the POCSO using a person's below the 18 years of the age, that means the child, in any pornographic material is punishable. and here the publishing or sending or selling that material is punishable. So this section 67b is just the extension of that, that even if we make even the publication punishable, so it would have the impact that lesser child will be used for the sexually explicit material. Okay, then the next or the fifth group we will discuss is about the cyber stalking. Here the IT provision would not be helpful because there is no special IT provision. And generally when there is the cyber stalking is like the stalking in the physical world. If someone is unintentionally observing your internet activity, sending you message intentionally many times, or replying on your on your comments, etc. So that type of the things is known as cyber stalking, and it always have the fearing in the mind of the accused. Generally the victim is a woman, but sometime even the male member can be the victim of the cyber stalking. So here we will discuss that what is the cyber stalking, how it happened, and what are the threat to it. Section 354D of the Indian Penal Code and section 509 of the Indian Penal Code would be helpful. If some person suppose there is your profile or the Facebook account, and some person use the words that is filthy. Okay, so in case if it is the woman, section 509 will come into picture, because section 509 is not limited only to physical things, it may be applicable to the electronic means. And there in the uh, Chhattisgarh, they have amended the IPC and have introduced section 509, I think B, and there they have expressly made it, if the anything through the telecommunication or the internet or information technology, if same thing is done, there is the punishment. Because the Indian Penal Code is come under the concurrent list, so the state and the central government can amend, but we read only the Indian Penal Code that is applicable to whole of India. In different state there are different amendment, and that were helpful. When I was there, as a district assistant district attorney in government of Haryana, I come across that in Haryana there is we have the theft under section 378. There is and punishment section 379. In Haryana, through the state amendment, there is offense is snatching. So snatching, the legislature has separated with the theft, because in the snatching, when person snatch the chain or bag, there is some threat. Always there are many instances reported in the everyday newspaper that the woman was even dragged to the 200 meters while the snatcher want to snatch his bag, etc. So separate offenses there. So in the but unfortunately in the Indian the penal code also, and in the IT Act we will not have the separate provision with respect to the cyber stalking. Then the sixth group we will discuss is about the cyber terrorism. See, the information technology is very helpful. At the same time we can communicate, we can be influencer, we can influence so large number of the person, but sometime for recruiting the people for the unlawful purpose or for the terrorist activity, through the speech, through the the hate speech arts, etc. This type of the things is done. So that is the cyber stalkings. In year 2009 the separate provision has been inserted to curb these activity. On the Zakir Naik also, this some charges were I think were framed, or there was some proceeding with some other person also. This type of the things is done. Maybe sometime the internet is using to giving the threat to the society and creating the havoc in the society. So here on the cyber terrorism we will discuss one case that is even before then this provision came into on the statute book. Rakesh versus CBI, Delhi District Court in 2011 after this case came into after this provision came into picture. So Delhi blast case, terror email sent by hacking Wi-Fi in the Mumbai. So these 6 group we will discuss, and then we will discuss another portion of the admissibility of the electronic evidence. See, in the Indian Evidence Act we have rules related to the evidences, which evidence we can produce, which evidence we can use in the trial or in the court. If you see section 136 of the Indian Evidence Act, that only the relevant facts can be the things has to be proved by the relevant fact. Section 5 is also saying what is relevant fact. From section 6 to 55 make certain facts is relevant, and only those things can be used by the court. Other cannot even be used by the court, because court time is the precious, and irrelevant things cannot be allowed to adduce. So there also electronic for evidences are categorized as the oral evidence and the documentary evidence. And then to the documentary evidence also, the primary evidence and the secondary evidence. The primary evidence is the document itself. There is the cardinal principle that the content of the document has to be proved by document itself. अगर document में क्या लिखा है इसी पे सवाल है तो वो document से होगा. But sometime it may be that document is not with the person, or document is not in this world, maybe it is lost, or it is stolen by some person, or maybe it is with the persons who cannot come into the India, etc. So in that case the secondary evidence is also admissible, and section 65 talk about those that when the secondary evidence is admissible. So there the amendment is done with respect to the electronic evidence. Section 65A and section 65B were inserted while this IT Act was enacted. Along with this in the Indian Evidence Act, this amendment was done. And these two sections talking about that to make the electronic evidence admissible before the court, there are certain requirements that has to be fulfilled. So only in that case the electronic evidence would be admissible. And so for adducing any electronic evidence before the court have to go through this way of complying with the condition of the section 65B, or you can say 65A read with section 65B. And on this case very authoritative judgment passed by the Supreme Court about the admissibility and the interpretation, so that we will discuss. Anwar PV versus PK Basir, Supreme Court decided on 18 September 2014. Then there is another judgment that came in 2020, where the Anwar PV versus PK Basir judgment was upheld, or you can say again reaffirmed by the Supreme Court. Arjun Pandit Rao Kotkar versus Kailas Khusan Rao Gorteyal. Okay, so these two cases we will discuss, and you will find out that how the electronic evidence has to be admitted, what are the requirement, and what is the law behind that. Okay, so this is the outer the outline. Now I think we should start discussion on the first group of offense. The first group is the tampering of the source code. So I am taking section 65 here to discuss. Section 65, if you read, says that, just give me 1 minute so that you also find your direct. And tampering with the computer source document, whoever knowingly or intentionally conceals, destroy or alter, or intentionally or knowingly causes another to conceal, destroy or alter any computer source code used for the computer program, computer system, computer network, when the computer source code is required to be kept or maintained by the law for time being in force, shall be punishable with imprisonment up to 3 years, or with fine which may extend to 2 lakh rupees, or both. And then the explanation. For the purpose of this section, computer source code means listing of program, computer command, design and layout and program analysis of the computer source in any form. So here we can dissect this section and see the mens rea portion is knowingly and intentionally. So the activity has to be done with this mens rea. So three things it is making punishable: conceal, then destroy or alter. So you can even write down the ingredient. The first is about knowingly or intentionally doing the act. The second is the act of concealment, destruction and alteration, either by any person himself or by assisting other to do that. Okay, and then the third is that the source code, this destruction, this concealment or alteration would be source code, computer source code. And the fourth one is that the computer source code either has to be maintained by law or is kept. Okay, maintained by law or is maintained by law at the time kept or maintained by the law for the time being in force. So these four requirement is there now. And then the punishment, now the first thing is that knowingly or intentionally, we know that the two stages of the mens rea it's showing. The second element, the destruction means you deleted that particular program. Alteration means you make certain changes in that program, certain changes, maybe that changes are positive effect, making that program profitable or not, that is immaterial, but changes are there. And the concealment means you have put that program in such a manner that the original person cannot access this thing. And then the third is the computer source code. Now the question is that what is the computer source code, because the whole section around the computer source code, this section 65 is protecting the computer source code. The offense is for doing wrong with this computer source code. So what is this computer source code and why so much protection to this computer source code? See, the computer source code is see, in the computer only understand 0 and 1. Okay, and so the language that we speak cannot understand by the computer, and the computer, to the computer we write the language, and so the language that the computer understand is known as the machine language or the first generation language, but that is difficult to understand with us. Then there was the second generation language, or you can say the assembly language, and the latest version, I'm just briefing because so that you can understand, is the high level language. So this high level language is the language that can be in the paragraph, etc. So many hyphen and other characteristics are used, and that is used with the computer. So the computer source code is actually that program or layout in which it is written in the form of the set of instruction to the computer, and accordingly computer perform the function. So that function it's doing or its resultant is known as the object code. Now this computer source code is well protected under the Copyright Act because it is also the intellectual property, and so much money is invested on writing the program. It's not an easy job. The person from the technical background may aware and know about it. And many our machines, many our things are that automatically using are use this computer source code. If there is any change in computer source code or the computer program, that whole machine will function otherwise. See, suppose there is a mobile, your mobile, there is the program, the computer source code. That's why if you have the SIM card, in the SIM card also there is the computer source code, that you having idea SIM card, so the only the idea services you are getting. If you have the Jio SIM card, only the Jio services you will get. And so the source code is very important, and that's why this provision is there. Now with respect to the source code, if a person knowingly or intentionally do either alteration or concealment or destruction, either himself or causing another person to do the same, that means the assisting both way, the section 65 will applicable. And then the fourth one is that whether the source code in itself, if only the source code is the requirement or there is other requirement. So the fourth element of the section 65 is that either that source code is kept or it is maintained by the law. So now what is the understanding that kept or maintained and then by the law? So whether this law will be come with the word kept or the maintained, and or these phrases are the distinction. Okay, so this was also the argument in the case of Sayyid Aspuddin that I am going to discuss now. Then the explanation attached to it is make it very clear again the computer source code to understand that the computer layout, computer program design, all would be computer source code. Now there was one important case, the first case I am going to discuss, Sayyid Aspuddin versus state of Andhra Pradesh. Here the Andhra Pradesh High Court got the opportunity to discuss the scope of the section 65. Yes, this case is there. Just give me 1 minute so that I can screen the share. See, the facts of this case are simple, that there was a complaint made by the head and sale of marketing wing of the Reliance Communication, Reliance Infocom Limited, RIM. So this in the Reliance India Mobile, in short RIM. So there was this scheme by the the Dhirubhai Ambani company, Reliance India Mobile, that on a certain, on a particular price mobile handset is given, and that was around 10,000 rupees, and on a particular rupees a tariff plan is also given for a particular time period. Now the some other persons, they wanted to make the changes in it. So because there are other competitor in the market, and allegedly in this case the Tata Indicom staff were booked. So those Tata Indicom staff were indulge in the activity that any person who having this RIM mobile phone, Reliance India mobile phone, they can change their plan by making certain changes in their mobile phone, and by that they will get the services of the other telecom service provider also, that are the cheap. Now this company or this handset was the proprietary of the Reliance India Mobile. I think maybe this is looking very atpata, but at that time it was happen कि आप पैसा दो आपको मोबाइल मिलेगा और टैरिफ प्लान मिलेगा उस पर्टिकुलर पीरियड के लिए. And they have made the complaint. Then the investigation happened, and through the investigation it was revealed that the person who having the Reliance India mobile phone, that person go to the a particular place in the Sikandrabad, Hyderabad and Sikandrabad, two twin city, and then there the Tata Indicom staff member take the mobile phone, went this mobile phone at some hidden place, make in the changes in the computer this source code available in this mobile phone, and then this mobile phone getting the services of the other service provider at the cheap services. Now when this all these things has come into the knowledge of the head of the sales and marketing wing of the Reliance Infocom Limited, so they agreed by it, because their name and their mobile phone or their business is hampered. So they filed the complaint, and finally on this investigation the FIR was lodged. So that FIR was lodged under the different sections, section 409, section 420, section 120B of Indian Penal Code, section 65 of the Information Technology, and section 63 of the Copyright Act. Now when the FIR got registered, to quash the FIR, I think you also know, one has to approach to the High Court, because in the Criminal Procedure Code 1973 you will not find the provision for quashing of FIR. FIR हो गई तो वो इन्वेस्टिगेशन होगी, इधर चार्जशीट और डिस्चार्ज या जो भी प्रोसीडिंग होगा, बट फॉर द क्वेश्चनिंग ऑफ द FIR, सेक्शन 482 of the CRPC that talking about the inherent power of the High Court. So with this complaint, these person against whom the FIR got registered, the Tata Indicom staff, they approached to the High Court and quashing of the FIR and contended. They contended that the first contention that yes, it was the computer source code, because whole the SIM, ESN, and this some bit is there, and accordingly it work. So this was the computer source code, no doubt about it. The first contention they took that the section 65 is talking about the computer source code of the computer or the computer program or the computer system, but we actually altered the computer the source code of the mobile phone, not the computer. So the section 65 is not applicable. The second thing is even and without prejudice to the first argument, if you see section 65, the offense is made only when the fourth elements, they said that either kept or maintained by law. So that means kept or maintained by law are not two separate phrases, but kept or maintained, and this by law will go with the both these words. That means either kept by law or either maintained by law. And here that computer this source code in the chip in that mobile phone that at that time attached to the mobile phone, not the separate SIM card. So that having the computer that neither kept or nor maintained by the law. So they have read this section 65 that only the computer source code, if either it is maintained by law or if it is kept by law, then only section 65 would be attractive. Now come to this case. When you see this case, the first para is about that how the case reached to the Andhra Pradesh High Court. So there you will find that under section 482. So this is the case history. Then the second para is about the facts of this case. The third para is also about the facts of this case, and then fourth is about the how the investigation has happened. Then you have to leave some paras and then come to the para number this 11, para number 11, 12 and 13. These three paras are important to determine whether the mobile is a computer or not. And in the last line of the these different definition has been discussed, like program, computer source code, etc. Then the para number 17, 18 and 19. These three para are is on the point that whether the mobile is computer or not, because the first argument was that we did the change of the computer the source code of the mobile phone, not the computer, and mobile phone is not the computer. So in these para 17, 18 and 19, you will find discussion that whether the mobile phone is computer or not from 17 and then 18. I'm not going to read these because we have already discussed. If you read these last line of the para number 19, I am reading this, that to uh, uh, even the very definition of the computer and computer network in IT Act, a cell phone is computer which is programmed to do among other the function of receiving digital audio signal and converted into the analog audio signal, and also send analog audio signal into the digital form externally by the wireless technology. So the High Court has observed that if you see the definition provided under the IT Act, that any machine that uh, you know at very high speed data processing device, so mobile phone at the same time converting the analog signal into the digital signal and transmitting to the another person's, getting the another person's the digital signal at the same time converting into the analog signal, and there is no time gap in it, and so the mobile phone is also the computer. So the first contention of these you can say the petitioner have been defeated, that they have converted or altered the computer the source code of the mobile phone, not the computer. On the second the second the contention that how the section 65 has to be read. For that, first you have to read the para number 14, and then you have to read the para number just para number 24. The para number 24 is finally is on the discussion that how the section 65 has to be read. The para number 14 I am reading you. A screen is visible to you. You also have to read with me. By the very definition of the computer source code, the list of program, computer command, design, layout, or computer analysis of the computer resource in any form is the computer source code. For the purpose of section 65 of the IT, going by the definition, ESN of the Samsung 91191 model cell phone handset or ESN of the LG 2030 model cell phone handset exclusively used by the second respondent, as well as the SID of second respondent, come within the definition of computer source code. So yes, it was the computer source code, that ESN number. ESN. Every cell phone operator is required to obtain SID from the licensor, the Government of India. Further, the ESN is the permanent part of the phone where MIN and SID are programmed into phone. When one purchases a service plan and have the phone activity, when a customer of the second respondent opt for its services, the MIN and SID are programmed into the handset. If someone manipulate and alter the ESN as per the case of the second respondent, the Samsung and LG handset, which are exclusively used by them, became usable by other service provider like the Tata Indicom. This handset, the Samsung and LG handset is using this word because at that time the Reliance India Mobile using the handset manufactured by these companies. Okay, so that's why they are saying that in the mobile handset there is the ESN, and this ESN has to be the license has to be get by the government of the India. Then therefore prima facie the ESN is altered, and ESN, as earlier it was held in the first lines, that ESN is the computer source code. So the offense of section 65 IT Act is attracted because every service provider like the second respondent has to maintain its own SID code and also give a computer specific number to each instrument used to avail the service provided. The submission that there is no law which requires a computer source code to be maintained, an offense cannot be made out, is devoid of any merit. The disjunctive word or is used by the legislature between the phrase when the computer source code is required to be kept and the other phrase maintained by the law. So the High Court interpreted, like I was interpreted, that there are two phrases, that the computer source code is required to be kept and the second phrase is maintained by law, not that the kept or maintained and then by the law will come both with the kept and the maintained. And so and therefore both the situation are different. This court however hastened to add that whether a cell phone operator is maintaining computer source code or not is a matter of evidence. So far as the question is concerned, Going by the allegation in the complaint, it became clear that the second respondent is in fact maintaining the computer source code. So that is the matter of the fact. And if there is an allegation against any person including the petitioner, certainly the offence of section 65 of the IT Act is made out, and therefore the crime registered against the petitioner cannot be quashed with regard to the section 65. So with regard to the section 65, it was held that it is not the unreasonable, and so the High Court said that with regard to the section 65 it cannot be quashed. So we are not going to discuss the latter part, because for us it's the work has been done. So in the Sayyid Aspuddin versus State of Andhra Pradesh, the court has even decided that whether mobile phone is computer or not, and also gave the answer that how to interpret the two phrases used, that the source code kept or maintained by the by the law. Okay, so with this I stop here. We have discussed. In the next class we discuss another case on the tampering, and then the section 66 also we discuss.